Hello, it's Roger Halson here, and I'm going to be delivering a short lecture on the topic of exemption clauses and limitation clauses. So let's get started on this lecture. If you look at the slides, you will see exemption clauses and limitation clauses, and the difference between them is fairly conveyed by the description, of course. An exemption clause will be a contract clause which seeks to avoid all liability, and a limitation clause will be a contract term that does not seek to avoid all liability, but which seeks to put a limit on that liability. They can usually be spotted fairly easily just by looking at the terms of the clause. Now, we always need to bear in mind that one of the functions of a contract is to allocate risk between parties. So if you look at the quotation by Mr. Justice Hobhouse, it is always relevant to bear in mind when construing a contract between commercial parties that the primary purpose of the relevant provision may simply be one of division of risk, often insurable risk. We sometimes say that in a commercial contract, the main aim when drafting that contract is to achieve clarity. It's not fairness so much as it's clarity. You are seeking to make clear to the commercial parties entering that contract who bears which risk. And if they do not wish to bear that risk, what they will do, as Mr. Justice Hobhouse notes, is they will go and insure against that risk. They might renegotiate the contract and say, I'm not prepared to bear that risk, or they might say, I'll bear it, but I want to insure against it. And so they might go to a third-party insurer and take out an insurance policy. Now, this has an important consequence for commercial agreements, which we'll see in a minute, which is that when it comes to commercial agreements, courts will try to give a very natural effect to the words the parties use. They won't try and put strained interpretations on them. They will assume that commercial parties know what they want, they allocate risk between them, and someone who bears a risk under a contract is either happy with it or, if they're unhappy to bear that risk personally, has arranged a party of insurance with a third-party insurer to recompense them if that particular risk happens. And this is nicely illustrated by the facts of an older case called photo production and secure recall. Because in this particular case, which we will look at a little bit later, there was a very clear exemption clause. So, under no circumstances shall secure recall be responsible for any injurious act or default by any employee, nor in any event shall the company be responsible for any loss caused by fire. Now, Secure Recall were providing security services, including a inspection at night, to Photo Productions factory, and Secure Recall were only being paid 26 pence per visit. So even adjusting for inflation, this was a very, very low cost service that was being provided. And the court in that case decided that one of the things which will sit beside such the low cost provision is the expectation emphasized in that clause that the person doing the inspections and providing the security services is not assuming liability for damage to the property. Now, the damage to the property occurred when the security guard they sent lit a fire to keep warm and set light to the very premises he was supposed to be safekeeping. But that clause is simply effectively saying, if you go back to Mr. Justice Hobhouse's statement, it's simply saying this service is being provided at low cost, and the consequence of that is that the risk under that exemption clause is clearly being allocated to the factory owner, who must insure against damage by fire, even if that damage is caused by the negligence of the person providing the security service. So to go back to what I said earlier, it's not about fairness. Yes, it's very unfair, we would say, that a factory owner should have their premises burnt down by the very people they employed to keep it safe. But they contracted for a cheap service with an exemption clause. I mean, I'm only speculating. It might have been that at the time of contract negotiation, Securicor might have said, well, we're prepared ourselves to assume responsibility for the negligence of our staff, but we want you to pay £1 per visit, 4 times the contract price, to cover the extra risk we are assuming, because we will then have to take out an expensive insurance policy. So I apologise for labouring the point slightly, but it is counterintuitive that what a contract is doing is allocating risk between parties. And in commercial contexts, it's trying to do that clearly, i.e., in a manner which allows that party to insure against that risk if the contract clearly assigns it to them. And this provision, which was upheld in photo production and Securicor, clearly allocated the risk of damage to the premises by fire to the property owner. So that concludes our general remarks about exemption clauses. Now, I now want to look at what I've entitled the techniques of control, because courts have developed a number of techniques by which they will seek to control the use of exemption clauses. And roughly, I've divided that into 3 different heads there. Quite often, these exemption clauses are not included in the written document. You go and park your car in a car park. There may be a notice as you enter the car park saying the car park owner, the owner of this land, is not responsible for any theft from the cars while on our premises. Now, we have principles called the principles of incorporation, which will determine when an unsigned document or notice, like the one at the car park, is incorporated into the contract. Because it is often the case that exemption clauses feature in these unsigned documents or notices, the principles of incorporation can be used as a technique to control exemption clauses. But if the unsigned document or notice is incorporated, or if the clause itself is actually in a signed document, we then have to interpret it. The courts will have to come to the clause and they will have to say, what does it cover? What does it do? And then the final control is statutory control. And there are 2 main statutes here which control the use of exemption clauses. The Unfair Contract Terms Act of 1977, which we usually refer to as UCTA, and the Consumer Rights Act of 2015, usually referred to the CRA. And the important distinction between these 2 acts is that the first act, UCTA, will apply when the contract is between 2 businesses, what we sometimes call a B2B contract. The Consumer Rights Act will apply when the contract is one between a business and a consumer, a private individual, what we sometimes call a B2C contract. So we're going to go through now those 3 control techniques. Incorporation. Well, we'll be familiar with the signature rule associated with a case called Lestrange and Grocob, that if the clause is in a signed document, then it will form part of the contract. And as you know, you are bound by a signed contract even if you have not taken the trouble to read it. But unsigned documents or notices are only incorporated into the contract if a number of preconditions are satisfied. And these preconditions are not alternatives, they're cumulative. They must all be satisfied. You'll see that incorporation requires the clause, if in an unsigned document or notice, to be in a document or notice reasonably expected to contain contractual terms. So in the case of Chapelton and Barry Urban District Council, which involved the hire of a sun lounger deck chair which collapsed, causing personal injury, it was held that the ticket given on hiring this sun lounger deck chair was not a document which would reasonably be expected to contain contractual terms, so an exemption clause printed on it was not incorporated into the contract. It was reasonable for someone to think that if they were given a ticket on hiring a sun lounger or deck chair, that they could reasonably think that that was merely given to them as proof of payment, not as containing contractual terms. Timing is important here as well, because it is necessary for the notice to be given at or before the time of contracting. If the contract is complete, giving someone notice of terms afterwards won't make them part of that contract. So in the case of Ollie and Marlborough Court, there was a contract for the hire of a room in a hotel. It was held that the contract was concluded at the reception desk, when someone then went up to the hotel bedroom, closed the door behind them, and saw contractual terms, including exemption clauses, on the back of the door. That was notification too late, because the contract had already been entered. But perhaps the most important requirement of incorporation is that it is said that reasonable steps must have been taken to bring the unsigned document or notice to the attention of the party subject to it. And this comes from a case called Interfoto and Stiletto. And it's actually a case that didn't involve an exemption clause, but it involved the incorporation of a unsigned document or notice. And this is the general principle that you have to judge the steps in all the circumstances of the case. So it's necessary for the party who's relying on this clause to show that they took reasonable steps to bring it to the attention of the other party. So if the notice at the entrance to the car park, was in tiny print, barely visible until you got 2 inches from it or something, obviously that would not be sufficient notice. But sometimes it's put more directly, and it's said that reasonable steps must be proportionate to how destructive the exclusion clause is to the rights of the party subject to it. So the more rights that are taken away by the clause, the greater the steps that must be taken by the person relying upon the clause to satisfy the test that they've taken reasonable steps. Lord Denning once threw away the line that sometimes an exemption clause is so destructive of a party's rights that it imposes the obligation on the party wanting to rely on it to put a big red hand in a contract with a finger pointing to the term, trying to encapsulate, as Lord Denning often did, this idea that the more destructive the rights, then the greater the steps that have to be taken to bring it to the attention of the other party. But even that, when we get to the stage that the term indisputably is a part of the contract, it then has to be interpreted. So what does it mean? Well, if there's doubt about the meaning of the written term, the interpretation which is most favourable to the party subject to it is taken. And this is called the contra proferentem rule. It's said that the term is interpreted against, contra, the proferentem, the person putting it forward. And it applies particularly when the contract is breached in a very fundamental way. If somebody has breached a contract in a way that is very basic, then there's the clause is interpreted in a way that would not usually expect it to exclude the liability that arises from a very basic breach of contract. However, the third bullet point here is that the rule applies less strictly to commercial contractors, i.e. in so-called B2B contracts. And this is really the proposition for which Photo Productions and Securicor now stands, because that is the case we rely upon to say that if someone expresses themselves clearly, then we will not take a strained construction or interpretation of the clause in order to avoid it applying. They were commercial entities. They were big enough and ugly enough to look after their own commercial interests. They were probably both very well advised by lawyers. And if they entered into that contract, which clearly said that there shall be no liability if the premises are damaged by fire, even if that fire arises through the negligence of the service provider, then that should be the effect of the contract. So moving on now, let's look at statutory control. And this is related to what we said earlier, because obviously I've mentioned two statutes. You'll see B2B contracts, as I'd said earlier, are regulated by UCTA, the Unfair Contract Terms Act 1977, consumer contracts, B2C contracts, by the Consumer Rights Act 2015. Now, the Consumer Rights Act 2015 actually consolidated to some extent and separated earlier legislation. But I think you can get the feeling that the statutory intervention came later. And something follows from this, because the doctrines of incorporation and interpretation were having to do a lot of hard work early on, in that they were the only tools that courts had to strike down exemption clauses they didn't like. Once these statutes came along and Parliament said, oh, we don't like the exemption clauses in these contracts in these circumstances, the courts had a more direct tool to strike these down. So in a sense, the heavy lifting, if you understand the phrase, that was done previously by incorporation and by interpretation is now able to be done by the statute. The courts don't have to use these other techniques to strike down clauses indirectly by saying they're not incorporated or by interpreting them in a way that doesn't apply to the damage that has occurred, because they have these direct attacks on them where Parliament has simply said clauses will not be effective in these circumstances. So incorporation and interpretation have perhaps become less important. They still have to be considered, but maybe less emphasis is placed upon them since the courts have had available these statutory schemes to control exemption and limitation clauses. So we're going to look first of all at UCTA, which is, again, to repeat myself, the statute that applies to B2B contracts. And there's a couple of general concepts, and I'd advise you to go and have a look at and read through these sections. Section 13 of UCTA gives a very wide meaning to the exclusion of liability. And Section 11 and Schedule 2 define the notion of reasonableness, which we will see is very important to these statutes, to the way the UCTA operates. Now, if I can just pause just to make a sort of very general point here. If a student came to me, I don't know, an hour, 2 hours before a contract law exam and said, I've got an hour worth of revision left, what should I do with it to greatest effect? I think I would probably tell them to go away and read carefully the small number of statutory provisions that we study in contract law. And the reason for that is this, that I think there's something about cases. People like cases. Maybe because they have names, maybe they're like old friends. People tend to learn cases well, but they do not like, it seems to me, statutory provisions. And so what I find, as having examined, in contract law at many universities for 35 or so years, is that when people make mistakes in relation to applying case law, they're often sort of forgivable, sophisticated mistakes. When they make mistakes in relation to statutes, they're often very simplistic mistakes, easily avoided mistakes. They give an overgeneral account of the contractual provision. So that's the basis for me saying that if you came to me just before the exam and said, how can I best spend, the next hour? I would tell you, go and read those small number of sections that we come across. Increase your knowledge of statutory sections in contract law. Sometimes a simple section is quite complicated, but we don't meet many of them. The Misrepresentation Act, section 2.1 and 2.2, the provisions of the Unfair Contract Terms Act and the Consumer Rights Act for exemption clauses, the implied terms that derive from statute under the Sale of Goods Act. These small number, the Law Reform Frustrated Contracts Act's provisions in relation to frustration of contracts. It's a very small number of statutory sections that you need to know for the law of a contract, but I think it's well to look at them. So on that basis, I'm advising you to go away and read, the key sections of the Unfair Contract Terms Act and of the Consumer Rights Act that we refer to in this lecture. So on the Unfair Contract Terms Act, I've referred to two general concepts. I'm now going to look at the specific substantive controls that Act imposes. And remember, we're dealing with B to B contracts. Section 2 deals with excluding liability for negligence. Section 2.1 says a person cannot exclude or restrict his liability for death or personal injury resulting from negligence. Section 2.2 says that a person can exclude or restrict his liability for other loss or damage resulting from his negligence insofar as the exclusion relied upon satisfies the requirement of reasonableness. So if you compare those two, both sections deal with excluding liability for negligence. Section 2.1 deals with excluding liability for death or personal injury. Section 2.2 deals with excluding liability for other loss or damage, maybe damage to property, economic loss. And Section 2.1 imposes a ban. You cannot exclude that liability. Section 2.2 says you can exclude that liability so long as it's reasonable to do so. So as you'd expect, the more severe penalty, the ban, is applied to the more catastrophic type of exclusion, trying to exclude liability for death or personal injury, as opposed to trying to exclude liability for loss of property or economic loss, which you can, caused by negligence, which you can do if it's reasonable to do so. So you can see that if you were discussing Section 2.2, you would then have to refer back to the concept of reasonableness, which I referred to, which you find in Section 11 of the Act and also in Schedule 2. Now, let's look at control in the Unfair Contract Terms Act. So this is excluding contractual liability. Section 3.2 says a contractor who contracts on the other terms, written standard terms of business, when himself in breach of contract, is not permitted to either exclude or restrict liability or to render a contractual performance substantially different from that which was reasonably anticipated. So we have two situations dealt with here. So when someone contracts on written standard terms, standard form contracts, when they're themselves in breach of contract, they can't exclude or restrict their liability. But it's also this extra provision that they can't give a performance that is substantially different to that which was reasonably anticipated. So you can't say, oh, I am conforming to the contract, it's just that you didn't expect this kind of performance. And then the proviso at the end, unless the contract satisfies the requirement of reasonableness. So again, you can see that as with section 2.2, if you want to discuss section 3.2, you need to understand the requirement of reasonableness, because section 3.2 doesn't say there's a ban on clauses. It says that the clauses are enforceable if they're reasonable. Now, just pause for a breath here, because I think you'll be able to intuitively understand when I say that examiners are often disappointed with the standard of answers in this area, because the thing that disappoints them is often that the lack of sophistication, hence my plea to go and read the statutes before you do the exam in the last hour maybe. I'm sure you will never be that desperate, but these provisions are slightly complex. They're slightly difficult because if you try to look for clear sky between them, you try to regard them as completely different. They're not. They overlap. Section 2 deals with excluding liability for negligence. So if you tried to exclude liability for a negligent breach of contract, Section 2 would apply, but also Section 3 could apply. Because Section 3 just refers to, so long as the dealing is on written standard terms of business, either could apply. So there's a notion that if you're trying to attack a clause, you're trying to show that it's invalid. You might be able to rely on more than one section of the Unfair Contract Terms Act. But they overlap. They're not coextensive. Because if the breach of contract was a breach of contract that was not negligent, Section 2 wouldn't apply. Section 2 only applies when you try to exclude liability for negligent breach of contract. If it was non-negligent, only Section 3 could apply, and then obviously only if it was on written standard terms of business. So you've got to look at, maybe make a note on each of these sections and just say what you think are the key provisions and get in your head the idea that they overlap, but they're not. So they're not separate and they're not coextensive in completely being the same. They have different areas of operation, but those areas of operation do overlap. And we now have a final section in the Unfair Contract Terms Act, which is excluding liability for breach of statutory implied terms. Because in contracts, sometimes the most important terms are those which are not spoken or written. They are the terms which are implied by statutes into that contract. The main group of terms that you will come across implied into contracts by statute are in contracts for the sale of goods, where you will know that under the Sale of Goods Act, Section 12, there's an implied term that if I offer to you for sale, this nice watch, there will be an implied term that the person offering the good for sale actually owns the good they're selling. In the Sale of Goods Act, Section 13, 14 and 15, there are implied terms that the goods being sold will conform to their description, Section 13, that they are of satisfactory quality or fit for purpose, Section 14, or Section 15, that they conform to any sample. So if you're selling goods and you offer a sample of those goods, it's an implied term that the bulk of the goods being sold are of the same quality as the sample. Now you'll need to refer back to your notes here on implied terms and be aware when each of those implied terms apply, and you'll see a difference that some of the implied terms will only apply when the contract is entered into in the course of a business. So under Section 13 of the Sale of Goods Act, Section 14 of the Sale of Goods Act, the implied term that the goods sold of satisfactory quality will only apply when that sale is in the course of a business. So if you buy a car from a friend, you will not be protected because that friend is just selling to you as a friend, not in the course of a business. If you buy a car from a garage, i.e. they're in the business of selling cars, then there would be an implied term. So there's different stages to consider here when you're thinking of breach of an implied term. You've got to look at the section that gives rise to the implied term, and then you've got to ask whether that liability can be excluded under the Unfair Contract Terms Act. So as it were, it's doubly important in that case to understand the statutory provisions. And the Unfair Contract Terms Act makes it very difficult for parties to exclude liability for these implied terms. It says in Section 6.1, there's a ban. You cannot exclude liability for breach of the implied term as to ownership under Section 12. But in Section 6.1a, it says you can exclude liability for breach of the Sale of Goods Act, Section 13, 14 and 15, insofar as it is reasonable to do so. So again, that section imports into it the important concept of reasonableness. So, Unfair Contract Terms Act is a complicated piece of legislation, so I've provided you a summary of its effects. You cannot exclude liability for personal injury or death caused by negligence, Section 2.1. You can exclude liability for other damage, for example, damage to property caused by negligence where it's reasonable to do so, Section 2.2. Section 3, where you contract on written standard terms of business, you can only exclude, restrict liability or give a different performance to what was reasonably expected if it's reasonable to do so. And finally, you can exclude liability for breach of statutory implied terms as to description, quality and correspondence with sample if reasonable under Section 6. Moving on, I've now got a summary of exclusion clauses under the CRA, the Consumer Rights Act 2015. So let's have a look at what they do. Well, this act only applies to contracts between traders and consumers. So this is the definitional provision which says that it will only apply to so-called B2C contracts. That's Section 61. A term is unfair if it is not in good faith and it causes a significant imbalance in the party's rights against the consumer. So the aim is to protect the consumer. Well, what does good faith mean? It means there has to be fair and open dealing between the parties. And the Act also contains what's sometimes referred to as a grey list. And this is a list of terms that are presumed to be unfair. So the presumption is they are unfair unless the party seeking to rely upon them can demonstrate their fairness. Unfair terms are not enforceable against the consumer. And some terms, for example, those excluding liability for death or personal injury, are never enforceable against the consumer. So if you like, that is a mirror under the Consumer Rights Act of the provision of the Unfair Contract Terms Act, Section 2.1. And the final bullet point here is that terms describing the price or main subject of the contract are not subject to the Act so long as they are transparent and prominent. What's that for? Well, I think in a little reflection, you'll understand why that's there. Because if you start reviewing terms of contracts, you've got to have a barrier to what terms you're going to review, because we generally do not interfere. The parties are free to contract however they want, and the English law of a contract is laissez-faire. It leaves people to do. It lets them contract on the terms they want, unless we think there's a strong case to intervene. But provision, once you start taking a class of terms and saying that those terms are reviewable, like exemption clauses, you have to be careful that you don't bring into review every term in a contract against a standard of fairness, because otherwise parties would be deterred from contracting because they would never know what terms were enforceable and what weren't. So it's stated explicitly, if you like, that this Act is about controlling exemption clauses. It's not about reviewing all contractual provisions, and that's writ large by saying, any contract term which describes the price or the main subject matter of the contract doesn't fall for review under this Act, so long as they are transparent and prominent. Now, my attempt to help with problem solving, because I don't think there's any topic where good technique is more important than in relation to exemption clauses and limitation clauses. Questions. And I think you should never be deterred from answering these questions, because they reward good technique. And there's something counterintuitive here, because these are the stages I'd recommend you went through in answering a question. You look at a question, you realise it involves an exemption or a limitation clause. They're usually quite obvious, because it will say the contract contains a clause, X excludes liability for this or that. So they're usually very obvious. But, and please don't misinterpret what I'm saying now, the first thing you need to do is, having spotted the clause, is ignore it. Because you need to work out what liability would arise if there was no clause, before we then go and ask, what is the effect of the clause on the liability? I mean, logically, in a non-exam scenario, you're a lawyer giving advice. Obviously, if no liability arises in any case, there is no breach of contract, or if there is a breach of contract, there is no damage. There's no point starting looking at exemption clauses, because no liability will have arisen in order to be excluded. So the first thing you have to do is to ignore the clause and say, what liability would there be in the absence of the clause? So you have to find that there is a breach of contract and that there is damage. And the next stage is to say, what is the effect upon that liability and damage of the exemption clause? So bullet point number 1, what loss can be recovered if there's no exemption clause? Then I go through the control techniques. Was the exemption clause incorporated into the contract? If it's in a signed document or notice, signed document, of course it was. If it was in an unsigned document or notice, we have to go through those requirements of incorporation. If it was incorporated, it does form a part of the contract, we then have to interpret it. Does it cover the loss that has occurred? And as we've explained, the courts take a less artificial interpretation than they used to in the past, and they're more likely to give it a more natural and less strained interpretation in a B2B contract. And then finally, if it is incorporated and it does cover the loss that has occurred, we have to ask whether it's affected by any of the statutory provisions. So thank you very much. I hope that's given you a good overview of the topic. It's stressed the importance of statutory provisions, and it's also given you some guidance on how to approach an exam problem in this area. So thank you very much, and I hope you've enjoyed the lecture.